All right. It may be safe to start now. Good afternoon, everyone. Thank you for joining the presentation on immigration options for fiancé or spouses. This webinar is being recorded and the recording link will be emailed to all attendees. The webinar is provided as an educational service by Alcorn Immigration Law. The information discussed by our panel is an overview only and should not be construed as legal advice or advice to take any specific action. Please be sure to consult with a knowledgeable professional with assistance with your particular legal issue. Last, please submit any questions you may have using the Q&A function. The questions do get shared publicly, so please do not share any sensitive information. We will try to get to as many questions as time permits. That's my little spiel there. So let's go ahead and get started. Give me a second so I can share my screen. Thank you so much. Again, thank you for joining us to discuss some K-1 visas, some green cards, and all of that fun stuff. We are Alcorn Immigration Law. We overcome borders, expand opportunity, and connect the world by practicing compassionate, cutting-edge, and rigorous immigration law in the service of the betterment of humanity. It has been a very fun and interesting 4, 5, 6 years now in the world of immigration. There has never been a dull moment, and we are still so glad to be here helping individuals realize their American dream with a pretty stinking good success rate as well. So I'm super proud of our team for that. This is me. I'm Anita Koumriqian, one of the partners at the firm, proud alum of Santa Clara Law and UCLA. I have my strongest expertise in immigration law in family-based immigration. So this is my favorite case types. I have familiarity with all case types, but family case types have my heart. I also have experience practicing family law, so divorces, custody, and all of that. But again, immigration is what I am made for because I'm an immigrant myself. I came to the US when I was 4 years old. I am a proud American, raised Armenian. Interestingly enough, though, I was born in Iraq. Here is proof that I'm an immigrant for any of those of you out there who didn't believe it, but trust me, I am. That's me down there, resident alien Anita. Pink card, not a green card, but it definitely was a green card. So don't know why we call them green cards. These days they're a little colorful, but I digress. And I went too far, actually. Cori, my incredible associate attorney, my mini-me, we wouldn't be able to do it without her. Please introduce yourself.
Yeah, thanks, Anita. So my name is Cori. I am the Family Immigration Associate Attorney at Alcorn. I've been at Alcorn for a little over 2 years now. I'm also a Santa Clara Law alumni. Before joining Alcorn, I was working at a small nonprofit assisting survivors of trauma with their immigration matters. Now I work at Alcorn assisting on all family immigration matters, which I really do enjoy. I am a child of an immigrant. I've always felt very drawn to immigration, so I do really enjoy the work and connecting with our clients.
Thanks, Cori. In addition to Cori, we have a pretty quickly growing team. This actually does not even capture all of our employees now. We have grown. We have to update this slide so that you can see all of the wonderful, beautiful faces that we work with. But everybody that you see on this screen is super passionate towards immigration. Either they are immigrants themselves, married to an immigrant, the child of an immigrant, whatever it may be. Every single one of our employees has a special compassion and passion towards immigration, which is why we are as successful as we are. At least that's what I believe. This is our network. At Alcorn, we really pride ourselves on the network that we have, the individuals that we support, the individuals that are supported by us. If at any point in time you are thinking to yourself, I need an attorney that can support me with my taxes, reach out to us. I will tell you, I will not touch your taxes with a 10-foot pole, but let me introduce you to an attorney that does know taxes, because we have a pretty vast network, again, that we are proud of. So let us help you get not only your immigration ducks in a row, but all of the ducks in your life in a row as well. What do we need to know about immigration? this is the line that I always say exactly after the sentence is everything, right? That's why you're here. Immigration is huge. Immigration is vast. And there is so much to know, but let's focus on one little thing today. And that little thing is just marriage-based green cards or K-1 fiancé petitions. So let's hop on a quick little airplane and go 5, 10, 15, 20,000 feet up in the air. And let's look at what the typical pathway for immigration is. So there's two ways that you can enter the United States. One way is you enter the US as a visa holder, eventually transition to getting your green card, and then finally graduate up to qualifying for US citizenship and becoming a US citizen. That's one way, one typical pathway. Another typical pathway is actually never stepping foot into the US at all until you have your green card. And then from there, again, graduate or become eligible for US citizenship. Example, I came straight away when I was 4 years old as a green card holder. Again, it was pink. But with that, it's the exact same green card, but just kind of different pathways, which we will discuss in a second. One of them is called adjustment of status. One of them is just the consular processing pathway, which we will get into a little bit more. I have to take a deep breath here because immigration during COVID, it has been a doozy. Cori, talk to us a little bit about what our lives have been like lately with COVID.
Yeah, immigration during COVID has definitely been different than a typical day with immigration. So we have seen delays with biometrics and interviews both inside and outside the US. However, we have seen a little bit of an uptick in the biometrics, but still some delays there. Attorneys are now able to appear telephonically at local USCIS interviews. I believe this is still being offered at, I think, all offices across the country, definitely in the offices local to us in California. The proclamation that was functioning as a visa ban has been lifted, but the COVID travel restrictions are technically still in place by a presidential proclamation. There is supposed to be an easing of these travel restrictions on November 8th, which I believe we mentioned on another slide here, but hasn't occurred just yet. With the slowdown of interviews, they are also offering expedited appointments for special emergent circumstances, but these are really hard to get in the US and abroad. Also, as of October 1st, the COVID vaccine will be required for all green card applicants, or it is required for all green card applicants. And this includes green card applicants that are applying within the US and applying abroad. So we'll touch on those two different pathways in a minute, but the COVID vaccine is now required. As far as entry requirements go, so if you do travel, you will need to get tested no more than 3 days before you travel by air into the US, show a negative result to the airline before you board your flight, or show documentation of recovery and a doctor letter. I do recommend, though, still contacting your airline or checking your airline, make sure you have the most up-to-date information as far as being allowed on a plane and during this pandemic.
Yep, things change. Honestly, what feels like hourly, definitely daily. So it's always better safe to double check than to be sorry.
Just some recent news for you guys here. So as I mentioned, Biden administration plans to rescind the COVID-19 travel bans and instead require proof of vaccination for international travelers beginning in November. We do know that this date is November 8th. Afghan parolees are required to report their vaccination status as well. And then another thing is USCIS continues to extend their flexibility responding to agency requests. So if any of you have like a pending application with immigration at this time, specifically with USCIS, and let's say they send you a request for additional information, they have extended the deadline for those.
Awesome, thanks, Cori. When all else fails, double check is basically all the advice that we have to give right now. And then as soon as we get additional updates, you will definitely hear from us with our newsletter. I know you all get our newsletter, so you guys will be kept up to date there. The October visa bulletin. So for the most part, family-based cases are not subject to the visa bulletin, but some cases are, and specifically the F2A visa category, which is those that are married to a lawful permanent resident, so a green card holder. Historically, the F2A visa category has been backlogged usually by about like a year and a half, 2 years, 2.5, 3 years. For the last over 2 years now, actually, this F2A category has been current, meaning as a spouse of a lawful permanent resident, you can apply for an adjustment of status, and you can most likely file the I-130 and the green card application concurrently without having to wait for the visa bulletin to become current, because do you see the C there? It already is current. Other visa bulletin categories, one that is a pretty daunting one is the F4 sibling category, which is again historically backlogged by around, I mean, you can do the math here, but on average, it's backlogged by about 10 to 15 years. Some categories are backlogged even longer, specifically Mexico, as you can see, it's backlogged by over 20 years, which is rough. So the sibling category is something that we can discuss or have discussed in prior webinars. If it's something that is of interest to you, reach out to us and we can definitely have more sessions on that as well. But this is a continuation of the visa bulletin here as well. Marriage-based immigration options. Cori, why don't you walk us through the difference between adjustment of status and consular processing?
Sure. So first up here we have is adjustment of status. So who can adjust their status? So people who are applying for adjustment of status are people who are applying for a green card in the US. So typically these applicants have entered the US with a valid visa or through the visa waiver program on their ESTA. When they are filing for this application, they are typically in valid visa status, even if their visa were to, let's say, later expire while the application is pending. There is an exception for spouses of US citizens. They don't necessarily have to be in valid visa status when they file their application. So if that applies to you, you can talk to us more about that. But that is an exception that is there that I wanted to go ahead and point out. How to get a green card through adjustment of status. So first is we recommend talking to an attorney, determine your eligibility first. Once you determine that you are eligible, you can have an attorney file an I-130 and an I-45. So Anita was mentioning the visa bulletin earlier. So sometimes we do file these I-130s first if the visa bulletin isn't current, but more often than not these days we are filing these applications concurrently and filing both the I-130 with the 485, and they are typically being adjudicated together at a green card interview. Would you agree with that, Anita, right now?
Absolutely.
Yeah, so we file those applications together. Usually next steps from there are getting receipt notices, USCIS acknowledging that they have received your application. From there on, you get a appointment to get your biometrics taken, so fingerprints and photo are taken of the applicant. And then while a green card application is pending, specifically adjustment of status, the applicant or the beneficiary is allowed to work with the temporary work permit. So they're eligible to file a temporary work permit and travel authorization application along with that green card filing, and it allows them to work and travel while their green card application is pending. So usually that's the next step in the process that you'll see as far as getting feedback from USCIS. Besides, after that that work permit application is pending, that travel application is pending, and you get adjudication on that, usually the next thing you're waiting for is an interview notice. So you'll ultimately get scheduled for an interview for the green card application at a local USCIS office. Here at Alcorn, we do provide I would say a really amazing mock interview for our clients. They do feel we over prepare you for your interview with USCIS. So once that's scheduled, we reach out to you, schedule that mock interview, get you ready for that interview. You then attend that interview, and after interview, you wait for a decision in the mail for the approval of your green card.
So one thing that I will add about that mock interview, it's critical to pre-prepare for the interview so that you know exactly what to take with you to the interview, what to say, what not to say, all of that fun stuff. The preparation that we do for our clients specifically, we hear it from our clients, we hear it from USCIS officers as well, is that we prepare our clients really well. And clients will say, gosh, Anita, you did the mock interview with me and you pretended to be the officer, because that's what we'll do. We'll walk through day of interview, what it'll be like. And the clients will say, you are such a meaner officer than the actual officer was. And I was like, I know, I prepared you well. And I asked you all of those difficult questions that we probably didn't think the officer would ask, but you got to prepare anyway. So those are fun to do.
I agree. What comes next though after getting your green card? So once you have an approved green card, your green card's in hand, you are able to legally work in the US and travel in and out of the US. And then if it is in your plans, you can also apply to become a citizen in 3 to 5 years, depending on your circumstances.
Yep. Awesome, thanks. So that again is the adjustment of status pathway, which you would go down if you are in the United States in valid immigration status currently, or maybe you entered the US years ago in valid immigration status, overstayed, and simply never left the US again after that. So if you find yourself in that position and have questions about adjustment of status, reach out to us. Cori, talk us through what consular processing pathway is like.
Sure. So consular processing is different than the adjustment of status. This is for applicants who are applying from their home country. So they are abroad. Typically, they, so like I mentioned, they're applying from abroad. So they're going to wait through the whole process in their home country. They're going to ultimately attend an interview at the US consulate in their home country. So how to get a green card through consular processing. So it's similar to adjustment of status, we do recommend talking to an experienced immigration attorney, determining eligibility first. Once eligibility is determined, your US or LPR partner, spouse would file the I-130 petition with the help of an attorney. You will have to, at this point with consular processing, wait for the I-130 petition to be approved before moving on to the next step. So let me go ahead and say consular processing is a more multi-step process. It's not filed all together and then you're kind of just waiting for your interview. There's multiple steps here. So the first one is going to be the I-130 petition and then getting that approval notice. Once the I-130 petition is approved, then the next step is your case being transferred to the National Visa Center. So once your case is with the National Visa Center, you do submit additional documentation through their online portal. That documentation will get reviewed, and then it will be, once it's reviewed and accepted, it's considered documentarily complete. So Anita, I don't know if you've heard, but they've actually changed the terminology here. So it was documentarily qualified, now it is complete. They mean the same thing. Once your documents once you're considered documentarily qualified, then you're just waiting for an interview at a consulate abroad. Similar with adjustment of status, once you get that interview time slot, we at Alcorn will prepare you with a mock interview. We prepare you with the documents that you need to take with you so that you feel good going into that interview. The beneficiary will attend that interview at the consulate, and if the visa is approved, they will get the visa in their passport. So what comes next after getting an approved visa in the passport? Well, the next steps are coming to the US. So you'll come to the US with your valid visa and you'll enter as a lawful permanent resident status, allowing you to work legally in the US and to travel in and out of the US, and also allowing you to apply for citizenship in the future once eligible.
Perfect. Yep, exactly. And so you have, once that visa is approved, you have 6 months to enter the United States with that approved visa. So you have to make sure that you are actually entering the US during that specifically allotted time, or else you will have to go through additional hurdles to prove that you're eligible. You'll have to basically not reapply for the entire green card process or go through the entire green card process again, but you're going to have to do the last step or bits and pieces of that last steps again. So it's very clear on the visa when you have to enter by, so you just have to make sure that you do enter by that specific date. Okay, so oftentimes what happens when I'm speaking with a potential client who is not yet married, they come to me and they say, hey, listen, we're not married yet. We're thinking about either the K-1 visa process, the fiancé visa process, or the marriage-based process, and we're not entirely sure. And I walk them through both options. So the K-1 fiancé visa is specifically reserved for individuals who are engaged to a United States citizen. So this one has to be a US citizen. You don't have the flexibility or the opportunity of saying, oh, I'm a green card holder, I'm going to do a K-1 visa. Nope, if you're a green card holder, your only option is marriage-based. So with this, the K-1 visa, very actually similar to the consular processing pathway that Cori just walked us through, but instead of filing an I-130 petition for alien relative where you're saying I'm married to a US citizen, you're filing an I-129F saying that I am engaged to, or I'm a US citizen and I am engaged to a foreign national. So with this, you file that petition with USCIS, that case is approved, and then from there, the case moves on to, again, the same pathway of consular processing. You don't make a pit stop with the National Visa Center, you go straight to the consulate, provide the consulate with the additional information and documents that they need. Ultimately, they are given a visa that's a single entry visa. So you can use it one time. You have, again, that same 6-month limit that you have to enter the US with. And then from there, you enter the US as a K-1 fiancé visa holder. Once you enter the US, you have 90 days to get married. And upon marriage, then you go through the entire adjustment of status process that Cori walked us through as well. So from there, you're not filing an I-130, you're actually just filing the green card application. So you're saying, I came into the US as a fiance, with a fiancé visa, I got married within the 90 days. Now what I'm doing is I'm filing for my adjustment of status so that I can get my green card. Same pathway follows with adjustment of status in terms of next steps and timelines and all of that fun stuff. So that's the fiancé visa process. How do you go through it? I kind of actually walked you guys through the steps already. And with that, it's the K-1 fiancé visa versus the marriage-based visa is what I'll touch upon next. But really deciding between the two, when I'm speaking again with a client or when I'm speaking with anybody, I tell them, what is your primary goal, right? Is your primary goal to be in the United States with your partner faster, or is your priority actually going through a shorter process and entering the United States or not losing your employment authorization or work ability? So again, I'll slow down in a second and I'll walk you through this. So how to pick which one? Again, ultimately, it's depending on the goals of the couples, both individually and as a couple. So with the K-1 visa, the pro here is you enter the United States faster. So let's talk timelines for a second. Let's talk pre-COVID, because COVID threw a wrench in timelines and processes. And frankly, I don't think it's fair to talk COVID timelines. I can touch upon, I know, Molly, I see your questions in the Q&A. I know you have some questions about timelines. I promise you we will go through those questions in a second. But talking high level overview, again, timelines, with the K-1 fiancé visa, on average, I would say the fiancé would enter the United States about, I would say, like 8 to 10 months after you file the K-1 petition, whereas the marriage-based route from start to finish can take upwards of like 15 to 18 months from start to finish. Now, with the K-1 visa, you're entering in as a visa holder, you get married, and then you file the green card process. Whereas with the marriage-based route, you're entering straight away as a green card holder with the immediate permission and opportunity to work in the US and travel internationally. With the K-1 visa, you don't have that. So pro is with the K-1, you enter the US faster. A huge con, which oftentimes diverts people from the K-1 fiancé visa process, is you don't have work authorization and you cannot depart the United States. So with this, the K-1 visa, once you enter, again, let's talk timelines of when you get that combo card that Cori was talking about, the work and travel authorization. So you enter the US, let's say you enter the US today. You get married within 3 months. So 3 months from today is end of January. End of January, you're married and you file the adjustment of status application. And then from there, is that the waiting game for your combo card, which pre-COVID took about 6 to 7 months. During COVID, it's taking closer to 9 to 12 months. So with that, somebody on a K1 fiancé visa probably and realistically speaking will not have work and travel authorization for an entire year at the least after they enter. So again, with the K1 visa, you're with your partner. For some people, that's all that matters. I don't care if I don't work. I'll be a stay-at-home wife. I'll be a stay-at-home husband. That's not a problem. At least I get to be with my partner. And that's a totally okay priority. For other people, they say there's absolutely no way that I cannot work or that I won't have the that I have to be landlocked in the United States. At that point, I say, okay, marriage-based is the pathway for you. It's gonna take at least 6 months to a year longer, but that wait is worth it for you. So the pro with the marriage-based route is you enter the US immediately with the permission to work and travel as a lawful permanent resident. But again, the big con is it's going to take longer for you to get the green card. But while it takes you longer to be in the United States with your partner, you actually get the green card faster this way than you would the consular processing way, because with consular processing, you're basically going through 2 immigration pathways. First is the K1. You have to consular process that K1 visa. And then on top of that, you have to file the green card application. So there's a lot there. If you have any questions, happy to answer them, put them in the Q&A, and I will go through the questions at the end. Cori, what is the conditional green card? Who gets a 2-year green card? Who gets a 10-year green card?
Yeah, so conditional green card is given, so it's a conditional green card, it's still permanent resident status, but it is conditional if your green card is approved and your marriage is less than 2 years old at the time of approval. So it's at the time of adjudication of your green card that determines whether or not you get that conditional green card. So like we said, they are valid for 2 years. What this means is that 90 days prior to the expiration of the 2-year green card, the green card holder needs to file an application or a petition called the removal of conditions to remove the conditions on their green card. And then once that is approved, they will have a 10-year green card. And basically this is US immigration's way of checking on this couple, making sure that they are still married and that they are in what they call a bona fide marriage or a good faith marriage, and that they haven't gotten a green card and now have gone their separate ways. So that's really what they're checking for. They're looking for marriage fraud. That's the main purpose of this here. I think you have another slide here, Anita. Yep. Okay. So eligibility for the 751, which is the petition to remove conditions, that's what the form is called. So like I mentioned, you do have to be a conditional lawful permanent resident. You received your green card based on marriage, and your green card is expiring within the next 90 days. So that makes you eligible for filing the I-751 to remove the condition on your green card. Applying to remove the condition. So when you actually apply, you are supposed to file this application jointly with your USC or LPR spouse. You file it during, again, that 90 period immediately before that green card expires. You file jointly, and you're, like I mentioned, just proving again that you are in a good faith marriage. So this is going to have this is going to be, you're just going to be providing additional evidence of your good faith marriage. And Anita, I think you're on the share screen here. Okay. All right. So next thing here, you can go ahead and go to the, sorry guys, I lost our spot a little bit. All right, so let's say you aren't able to file jointly with your spouse, and what can you do from there? So there's a variety of waivers for that jointly filed requirement. So who can apply for these waivers? So let's say your marriage was entered in good faith, but your marriage has now been terminated through divorce or annulment. You could file for a waiver. Let's say, unfortunately, your spouse has passed away in that 2-year period. So you can also file for a waiver for that requirement there as well. If you were subject to any kind of domestic violence by your US citizen or LPR spouse during the time of the marriage, during that 2-year period, you can also qualify for a waiver. Or if the termination of your green card status or removal from the US would result in an extreme hardship, you could also qualify for a waiver for that jointly filed requirement as well.
And then so a couple of things for that I'd like to add here as well, that like common mistakes with the I-751 is people will file a renewal of their green card when it comes time to removing their condition. So they'll accidentally file what's called I-90 instead of I-751, and that is not going to remove the conditions of your green card. An I-90 is for somebody who has renewed their, who has to renew their 10-year green card, whereas the 751 it serves a different purpose. It serves the purpose of proving that you are still in a good faith relationship, or maybe you're not in a good faith relationship anymore. It ended up in divorce, and that you're showing that you first entered the marriage in good faith. So it's just a common mistake that people will run into. Let's see. All right, moving on. So beyond green cards, after you've had your green card for a while, you will be eligible to apply for US citizenship. So applying for US citizenship means you have to have been a green card holder for either 3 years or 5 years. In most cases, it's 5 years. In some family-based situations, you qualify in 3 years, which I'll touch upon in a second. You have to prove that you meet the physical presence requirement of US citizenship. You have to prove that you're an individual of good moral character, and you have to go through an interview. You'll be tested on your civics, your English reading, writing, as well as civics, where they'll ask you questions like, who was the first president? Where is the Statue of Liberty? What is the national anthem? Questions like that. So that's kind of just what you will, for the most part, need to do in order to qualify for US citizenship. The very first thing that you have to make sure is that you're applying at the right time. So if you're married to a United States citizen, you've been married for 3 years, and you've been living with that US citizen spouse for 3 years, from there you qualify for US citizenship based on the 3-year timeline instead of having to wait for 5 years. So a pathway that a lot of individuals will take, because it's 2 years, you're going to become a US citizen and be able to get your US passport in 2 years faster than most people can. Let's say I got my green card based off of marriage, or somebody got their green card based off of marriage. They got divorced, and then they want to apply for US citizenship. Because they're divorced and no longer married to that US citizen, they have to wait 5 years. You still qualify for US citizenship. You just have to wait 5 years to qualify for US citizenship instead of being able to have that shortened 3-year timeline. And then going further into that, the 50% physical presence requirement here, there's a couple of different prongs or thresholds that you have to meet with the physical presence requirement, and that you have to prove that in either the 3-year statutory period or the 5-year statutory period, whichever it is that you qualify for, you have no trips longer than 6 months in duration. And of those, again, 3 years and 5 years, you have spent 50% of your time in the United States. So with that, it's a two-pronged query really there. And then with good moral character, it's really just making sure that you've been you're a well-rounded person. You've been paying your taxes. You don't have any overdue taxes. You don't have any crimes. If you do have any crimes, that it's not a crime that disqualifies you. You're not on parole, or you were not on probation during that statutory period. So a couple of different things with citizenship. Again, you always will have to go to an interview for this, at which time they'll ask you questions about your citizenship eligibility. They'll ask you, they'll run through those English tests with you. Even if you're from the UK and you speak what I would say is the purest English, they're still going to test you on your English reading and writing. Typically, the questions are, who lives in the White House, and then they'll ask you to read that on a screen, and then they'll ask you to write out the president lives in the White House. So easy peasy questions for the English reading and writing for somebody who speaks English, but for somebody who doesn't, you got to study. And they tell you exactly what it is that you have to study. So no issues over there. And then the civics test, it's 100 questions again that you have to study. Of those 100, they'll ask you 10 of those questions. As soon as you get the first 6 correct, then you pass, and then there's no issues there. So you just have to have a solid D average with that civics test, and again, you'll be okay and you'll be good to go. A joke that I always tell people or clients who are a little bit freaking out about the tests is, my grandma came to the US with us actually when I was 4 years old, and she spoke no English whatsoever, and she passed the English reading and English writing and that civics test. I don't know how she did it, but I always tell people, if my grandma who spoke no English passed these exams, so can you. So I have faith in you. So filing for US citizenship, oftentimes that I-751 removal of conditions process can actually take 18 months, 2 years. And so doing the math, if I qualify, if I have to file the removal of conditions at the 2-year anniversary of having my green card, and then I qualify for US citizenship at the 3-year anniversary of having my green card, what if my removal of conditions is still pending? Well, what happens actually is USCIS says, file that citizenship application regardless. We get this from the local offices. They tell us that. File the removal of conditions, file citizenship while the removal of conditions is pending, and we'll actually do both at the same time. So again, same concept, even while this the process is pending, file, and both your removal of conditions and the citizenship application will be adjudicated at the same time, which is pretty awesome. So no issues there. That is actually all of our material for today. Let us know what we can do to support you. Consider us resources. If you have any questions, comments, concerns, let us know. Our social medias, follow us on there. We try to provide as much information, content, education as possible. We have a podcast as well, Immigration Law for Tech Startups. There's a new episode every Tuesday. The episodes are fun, they're light. We try to keep them entertaining. So if you're a podcast listener, have a listen. Mostly they're podcasts done by Sophie. I am a frequent guest on it, and so is Cori as well. So have a listen, and if there's any specific content that you want from us that you feel like we're not giving enough light to, let us know, and we'd be happy to add to our content, what we provide. So now let me switch over to our Q&A, and we'll start answering those questions. All right, so our very first question: as a sponsor for my foreign spouse, how does the affidavit of financial support work in consular processing if our financial life is overseas? This is a great question. Cori, do you want to handle this one?
Sure. So I think this would require ultimately a consultation with an attorney to figure out what is the financial situation of your life, because how you're going to, there's a lot of strategies that can be put forth with an affidavit of support for consular processing. So I think it'd be important to figure out, if you have assets, where are they located? Is there some maybe located in the US, or are they all abroad? Is the petitioner earning income abroad? And then also we'd want to discuss, your plans to relocate to the US if petitioner is living abroad as well. So I think this is a question that would require more information in order to answer it correctly and thoroughly and give you the best strategy for your specific situation. Would you want to add anything there, Anita?
No, that's really it. But basically it's possible, but sometimes we'll likely tell somebody, consider getting a joint sponsor, because it's gonna be easier for you. Next question: for consular processing to enter within 6 months, does this refer to entering the country or moving to the country? Specifically, can you enter the country for a few weeks leave, or must you enter and reside in the US for a specific amount of time? You can enter the US as long as you're entering the US and you're activating that green card. and the visa stamp on your passport says that you can travel on it. Most of them usually do. They say that you have it's for multiple entry and you can use it to travel internationally. Then you can enter, activate the green card, go back, and then just make sure that you're coming back and forth enough so that you don't abandon the green card. Green card abandonment is a thing as well. So you just have to make sure that, again, similar to citizenship, you have no trips longer than 6 months in one single duration at any given time. All right, what is the typical timeline for consular processing? This is the question that I punted earlier because it's a tough one to answer. Pre-COVID, consular processing took about 15 to 18 months, I would say, on average. During COVID, I really don't know if I can actually give you a timeline because we haven't had a case go from start to finish that we've worked on through COVID, because right now the world and the immigration processing times are a bit of a mess because of COVID. I would say with COVID, it probably is taking closer to like 2 years if you file a brand new case, because the consulates for the most part are closed and they are not, they're operating on diminished capacity if they're operating at all, causing delays, backlogs, and all of that not fun stuff. So again, pre-COVID typical pathway, which is what we're hoping life will go back to quickly, is about 15 to 18 months for consular processing. Next question. If you are not supposed to get married on a tourist visa, can you come in with one, get married, then apply for a K3 within the US and go abroad for the interview when it's scheduled? The K3 is never talked about, but in theory, wouldn't this allow you to come and leave the US once granted? I think
so. The K3 is for the K3 is you have to first file the I-130 petition, and once you have a pending I-130 petition, then you're eligible to file for a K3, which allows the foreign national to enter the U.S. and waits for that I-130 to process, right? But the reason the K3 is, I think, really talked about, at least every time I've looked into it for someone, is because you might as well at that point just wait for the I-130. Exactly. So that's how I've always advised clients, and that's why they've ultimately not chosen that K3 route. And I think that's probably why a lot of attorneys maybe don't talk about it as much.
Exactly. The K3 visa in theory is brilliant. It makes so much sense. In practice, honestly, it's silly to go through unless some extenuating circumstances, but it's silly to go through the K3 process, because the K3 processing times are over a year for that K3 visa specifically alone. So it honestly does not make sense to go through the K3 process. But let me touch upon the very first portion of your your question. If you are not supposed to get married on a tourist visa, can you come in with one, get married? Let me stop you there. If you come in as a tourist and get married, that's actually okay, as long as you leave the United States at the end of your tourist visa. Where the issue is entering as a tourist, getting married, and then going the adjustment of status pathway. That's an immigration no-no, because when you're entering as a tourist, you're saying, in 6 months, I'm going to go back to my home country, don't worry. But when you enter the United States as a tourist, get married, and then leave the US, you're not doing anything wrong. You're entering the US, getting married, and then leaving, abiding by the tourist visa rules, regulations, conditions, everything there. So that's actually not a problem. What you could do at that point is enter the US as a tourist, get married, leave, go back to your home country for a good chunk of time, and then come back again as a tourist, visit your spouse, and then go back again for a specific period of time, and then just hop back and forth until the consular processing pathway is done. You get your green card in your home country, and then you enter the United States. That is the most conservative approach that you can take if you want to still come and be with your spouse, but also while making sure that you're not breaking immigration laws by doing anything funky. If you have more questions about that, happy to follow up there. But that's a pathway that I often tell people to go down. Okay, next question. I was a Fulbright scholar and I'm spending my 2-year home residency requirement in my home country. Can I get the ball rolling with applications / papers, etc., even before the end of the 2 years? Thank you. Yeah, actually you can. You can start the I-130 process and get the ball rolling there. And then you're going to have to make sure that your 2-year foreign residence requirement is satisfied before you get to the actual the National Visa Center and consular processing portion. So steps 2 and steps 3 of the process. But you can absolutely get started with the I-130 because the I-130 in and of itself takes, I would say on average, about 6 to 8 months. So once you're like 6 to 8 months away from completing your 2-year foreign residence requirement, get started with the green card process at that point is my suggestion. Anything you want to add there, Cori? Feel free to chime in if you have anything. If you are currently living abroad and are planning on getting married to a US citizen but want to get married overseas, then get sponsored and apply for an immigrant visa before moving to the US. Is this possible and recommended? Hold on, let me read that one again. I don't think I understand. I don't see the question. You can, oh, I understand it. Yes, you can get married overseas. You don't have to get married in the United States. I think I'm understanding that question correctly now. If I'm not, please correct me. But you can get married anywhere in the world that it will recognize your legal marriage. It has to be a marriage. It can't be a domestic partnership. It can't be any of that stuff. It just has to be a marriage. It can be husband and wife and wife, husband and husband, as long as the country in which you're getting married legally recognizes that marriage as a marriage union, that's totally fine. The only additional step that you would have to do is if you get married in a country that the marriage certificate is not in English, this only thing that you're going to have to do is get that translated. There's no issue about having it notarized or getting an apostille for it. We just need a copy of the marriage certificate or the marriage license, whatever it's called. We have to make sure that it's valid with the reciprocity table. And if it's not, we'll give you the guidance and we'll support you through that process as well. All right. And what is the right path for someone already working in the US on a TN visa and wants to marry a US citizen? This one's a little bit complicated in that a TN visa is a single intent visa saying that when I'm coming to the US to work for this specific company. Once my TN visa is expired, I'm either going to renew my TN visa, get another visa, or I'm going to go back to my home country. And so with that, if you enter the US on your TN visa, you get married and then file a green card application, kind of serves the same idea or concept as if you enter the US as a tourist. Again, think single intent visa saying I'm going to go back to my home country. It could end you up in a little bit of funky water with immigrant intent. But with that, as long as you wait 90 days after your most recent entry on TN, and then you get married and then file a green card application, it should be fine. But definitely for a situation like that, consult with an immigration attorney so that they can support you through the process to make sure that you're not in any murky water there. But it's possible. What's the process and timeline of a green card from a son to his mother? That's actually the exact same process, exact same pathway, exact same timeline as it is being married to a United States citizen. A child can only petition for a parent if they're a US citizen. So that's the only difference there. You can't be a green card holder to petition for a parent, but same process, same pathway as it would be for a as a spouse. If an F1 visa holder gets married in the US, do they have to leave the country at some point in order to change status? Similar to a TN visa, an F1 visa is a single intent visa. So with that, again, a little murky-ish, I would recommend waiting at least 90 days from your most recent entry as a student And then after that, getting married and filing the green card application. But again, consult with a knowledgeable immigration attorney to support you through that so you don't run into any issues with immigrant intent there as well. It looks like I've gotten to all of the questions in the Q&A function. I see some questions in the chat, which I will read through as well. If you guys have any additional questions that are not in the chat already, please put them in the Q&A function so I can walk you guys through those questions as well. Is K1 authorized to work in the US? A K1 visa holder is not authorized to work in the US until they get the combo card and the work authorization through the marriage-based green card, which is why oftentimes people will shy away from doing the K1 visa process because they will not have work authorization for quite some time after their entry. So the answer is yes and no. You will get work authorization. It'll just take some time. I answered that question already. If my spouse gets an offer of employment in the US, can this help with an I-130 visa, marriage visa, or would this be a separate process and no bearing on the visa process? If an I-130 is specifically for spouses of a US citizen or a lawful permanent resident, or maybe a US citizen. It's a family member having the permission to petition for another family member. The employment-based pathway is a completely different form and it's a completely different process. It's called an I-140, which it's a huge and vast area of immigration as well that we won't be able to cover today. If you have any specific questions about employment-based pathways, reach out to us and we can have a consultation to answer any of your specific questions that you have about the employment-based green card process. Or you're more than welcome to check out the resources that we have on our social medias, on our website and our podcast, whatever it is. We have a lot of information out there. And if you have more questions, let us know and we can support you with that. I don't see any other questions. I can stick around for a couple of more seconds to see if any questions trickle in. But that is our programming for today. If you have any questions, consider us a resource. Again, let us know what it is that we can do to support you. And then we'll take it from there. Thank you all so much for joining me, and Cori, and you're welcome. If you have any additional questions, let us know, and have a good rest of your afternoon. Take care and bye-bye.
Bye.